The ornate marble chamber of the United States Supreme Court had seen its share of historic moments, but never one quite like this. Denzel Washington stood motionless at the lectern in Courtroom 3, his navy suit impeccably tailored, his eyes steady beneath the cold lights of America's most revered legal arena. Behind him, the marble columns loomed like silent sentinels. He was no stranger to stages, but this one was different. Here, lines weren't scripted. Every word mattered in a way that could reshape law and lives. Just moments before, Chief Justice John Roberts had interrupted with a sharp voice that sliced through the room like a scalpel. "Mr. Washington," he said, leaning forward, "I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." Gasps didn't echo, but tension did. The room was electric. Clerks stiffened in their seats, attorneys exchanged raised eyebrows, and a journalist's pen scratched furiously against a notebook. It wasn't just the disrespect in the Chief Justice's tone, it was the implication. A man celebrated for commanding the screen was now, to some, trespassing in sacred legal space. But Denzel didn't flinch. He hadn't come here to act. He'd come to argue. What the Chief Justice, and the nation, did not yet understand was that Denzel Washington had spent 5 quiet years earning his law degree from Howard University, writing papers between takes on blockbuster films, reading 19th-century case law in trailers, poring over constitutional theory while others were out celebrating premiere nights. He had come not with celebrity, but with scholarship. And now, as his gaze met the Chief Justice's, he felt none of the intimidation that others might. He had prepared for this moment, not to survive it, but to own it. "Chief Justice Roberts," Denzel began calmly, voice deep and unshaken, "my argument is rooted in the historical understanding of the Fifth Amendment, as articulated by this court in decisions such as Timms v. Indiana. But perhaps we should examine the textual and historical evidence together." And with that, he laid a worn leather-bound copy of the Constitution onto the podium. Inside were handwritten tabs, originalist sources, and something far rarer in that courtroom, perspective from outside the elite legal aristocracy. Roberts hesitated, just briefly, but it was enough. This wasn't celebrity activism. This was war in the language of the law. And Washington was fluent. The shift in the courtroom was unmistakable. What began as a novelty, a Hollywood icon arguing before the Supreme Court, was transforming into a confrontation of substance. Denzel Washington, once met with thinly veiled condescension, now commanded the room. Chief Justice Roberts, still trying to test the actor-turned-advocate, leaned forward. "Your brief argues that civil forfeiture was historically limited to admiralty cases. But what about the Palmyra, Mr. Washington?" Many seasoned lawyers had faltered here. Denzel didn't blink. "With respect, Chief Justice, the Palmyra involved maritime piracy, where personal jurisdiction was impossible. Justice Story's logic doesn't justify domestic seizures from American citizens who are fully within the court's reach." He flipped to page 23 of his brief, pinpointing the argument without hesitation. A ripple ran through the courtroom. This wasn't theater, it was precision. Justice Alito jumped in. "You're asking us to overturn Bennis v. Michigan, where we allowed forfeiture from an innocent owner?" "Not overturn, distinguish," Denzel answered. "Bennis involved property directly used in a crime. Here, we're talking about land seized based on a third-party street-level offense. The Constitution demands more." Skepticism turned to interest. Justice Kavanaugh leaned forward, his tone no longer dismissive. "So you'd limit civil forfeiture, but not eliminate it?" "Exactly, Your Honor. Keep it where it belongs, piracy, customs, cases without jurisdiction. But when the state can prosecute and doesn't, yet still takes property, that violates due process and the takings clause." Justice Kagan finally spoke, visibly impressed. "Mr. Washington, did you conduct this historical research yourself?" "Yes, Justice. Nights, weekends, between sets. Law school gave me tools. Justice gave me purpose." The silence that followed was not from disbelief, but from respect. The courtroom had come to realize this wasn't a performance. This was a reckoning. The courtroom was silent. Denzel Washington had just delivered what many would later call one of the most captivating oral arguments in the court's modern history. There were no interruptions. No gavel. Just a pause filled with awe. Justice Clarence Thomas, normally silent during oral arguments, finally spoke. "Mr. Washington, your originalist approach is refreshing. Would you have us overturn Bennis versus Michigan?" Without hesitation, Denzel answered calmly. "Not necessarily, Justice Thomas. Bennis involved a direct link between the crime and the property. Henderson does not. This court can distinguish it while restoring historical limits on civil forfeiture." The Chief Justice, whose skepticism had visibly softened, leaned forward for one last challenge. "And if we were to adopt your framework, Mr. Washington, what test should guide us?" Now, it wasn't interrogation. It was engagement. An invitation to shape doctrine. Denzel raised 3 fingers. First, a substantial connection between property and criminal activity. Second, clear and convincing evidence that the owner knew and consented. Third, the forfeiture must serve a genuine public use, not just government profit. A moment of silence followed. Then Chief Justice Roberts, with a notably changed tone, said, "Thank you, Mr. Washington. Your argument has been exceptionally informative." In those few words, a quiet shift had occurred, an acknowledgement that Washington had not only earned his place before the court, but possibly changed it. 6 weeks later, the Supreme Court ruled, 7-2 in favor of the petitioner. Roberts himself authored the majority opinion, quoting Washington's proposed test directly. A footnote praised the amicus curiae counsel for exceptional historical research. Justice Sotomayor highlighted the disproportionate harm forfeiture laws inflicted on marginalized communities. Justice Thomas called for a broader re-examination of forfeiture practices. And across the legal world, something changed. Law professors assigned the Washington argument in their syllabi. Legal blogs dubbed it the day the court listened to a student of the people. Applications to law schools, especially from underrepresented communities, spiked. Denzel, true to form, didn't take a victory lap. Instead, he launched the Washington Justice Initiative, a nonprofit aimed at defending property rights for communities most vulnerable to abuse. Months later, at a civic forum at Georgetown Law, Roberts and Washington appeared side by side, once courtroom opponents, now collaborators in reflection. Roberts closed the evening with humility. "I learned something that day. Legal brilliance can come from anywhere. What matters is the argument, not the biography." To that, Washington simply replied, "In law, like in acting, truth comes from preparation. And justice starts when someone is finally heard." He entered as an actor. He left as a legal legend. Not because of his fame, but because in the moment that mattered most, he was ready.